meeting when the Post Oak Savannah Groundwater District General Manager Gary Westbrook asked for essentially what I take to be a jerry-rigged DFC process. That's how I understood it, as a cover for Vista Ridge. Now, that's my interpretation. I'm going to move on to LCRA. They should, and they darn sure know better than to push for a hearing in a rural community online and in the middle of a pandemic. This tells me that they really could care less to understand what is happening to local wells and to our aquifer, as Vista Ridge is now pumping full bore, and within just a few months, we're seeing some serious impact. This also tells me that LCRA management has gone the same way as SAWS. The sheer arrogance of LCRA management, I'm talking specifically about Phil Wilson and John Hoffman, to endanger everyone that has to be in the hall tonight and to make it hard for citizens to participate, I find truly sickening. Board members, you make the decision, you make the final decision on this permit, and I'm sure you know it is your responsibility to do something about it if the proposed decision is not right. If they recommend you require both the Simsboro and Colorado River system to be monitored so we know what heavy pumping will do to them, they are obviously right. But giving any big pumper more water than they have proven can be pumped without unreasonable impacts to our water supply, the resource that you are sworn to protect is clearly wrong. Vista Ridge has cost your landowners a great deal of money in a short 6 months at a very hard time for unexpected large expenses. This will continue to affect them for years. Please do not walk away from them now when you know just one single project like Vista Ridge or a recharge or another LCRA can affect these wells. They're to be seen until proven otherwise as the canaries in the mine, these well owners. There are plenty of brains, heart, and creativity on this board. I have a lot of faith in you. My only question is if there is enough of you with the courage it takes to do the right thing tonight. Thank you for your time.
Thank you, Linda. I will now call back Michelle Gangus. Michelle?
Yes, sir. Can you hear me this time?
Yes, ma'am.
Thank you for your patience. And good evening, board members. My name is Michelle Gangness. I'm a landowner from Blue and a spokesperson tonight also for the Simsboro Aquifer Water Defense Fund, or SAWDEF, just as Mr. Brown was. I'm sorry to have to rely on just the telephone tonight, but you probably wouldn't care to see me anyway. Despite best efforts to deter us rural bumpkins from having any say, I hope there are members of the public tuned in, and I also hope the legislature and Sunset Commission, before whom LCRA's board promised to do better with public outreach, are also watching. I won't go over the same reasons that everyone has given you for thinking that this is an ill-considered hearing. The Lost Pines District, and specifically you board members, have to face some tough questions. We always appreciate your service, and I at least trust you struggle with issues to try to get it right rather than just struggle, which you sometimes seem to do. But there are, in fact, some unfortunate public perceptions about how this board goes about managing our privately owned groundwater, most recently evidenced by your going ahead with considering this mega permit and 2 others, while your constituents are reeling from expensive well impacts in Lee County after a mere 6 months of Vista Ridge pumping, with slow or no response from the district. I've got the same idea that others have had. Why don't you just say no action on permits till we get this figured out? Some people see you as transparently biased against ordinary landowners and well owners, giving deference to those who buy water rights and then exploit the water. They believe their interests are then marginalized in the public policy discussions too. Every once in a while, the public gets a little glimmer of real transparency before it gets shut down by your advisors. I'm fully convinced your advisors don't want you to worry about mere landowners and well owners, but that doesn't mean there's nothing you can do. How aquifers should be managed has a simple answer as far as SAWDEF is concerned, and I think it's the same answer that Mr. Wallace read from your management plan or from your website. If we as a society want to avoid committing ecological suicide, there's no alternative but to manage aquifers in a way that assures resiliency of the resource by developing it only in sustainable ways, a way that develops the resource to meet the needs of the present without compromising the ability of future generations to meet their own needs. So here's where you come in as the regulators of the rule of capture. Frankly, it won't feel to us that you're managing the big picture unless at the end of this journey, your constituents know that you called LCRA's bluff, that they can simply demand an arbitrary amount of water without any basis for asking for so much, that you don't have to just take LCRA's word for what impacts are unreasonable, that you applied the best available science and searched for localized data with monitoring of all aquifer formations and the Colorado River on LCRA's dime, even if that means this permit won't look like past permits. That you did that to at least try to protect our wells before they are damaged. And that you won't allow an applicant to get away with telling your constituents they should have known better than to spend their hard-earned money to access their water if they didn't go deep enough to protect themselves from LCRA and others. And LCRA sure as heck doesn't have any duty to assist them in their eyes. Thank you, as always, for your service and your attention to your duties. We all have faith in you. Thank you.
Thank you, Michelle. And lastly, I'll call back again Cindy Skinner. Cindy? Okay. I will ask, is there anyone who did not sign up that wishes to address the board? Hearing none, then I will move on to item number 4, which is the final hearing on applications of the Lower Colorado River Authority for operating permits and transport permits for 8 wells located in Bastrop County, Texas, and the administrative law judge's proposal for decision issued in SOA docket number 952-19-0705, recommending granting said permits an aggregate amount of 25,000 acre-feet of water per year from the Simsboro Aquifer, along with other terms and conditions. The applicant will be the first one to get up to speak. I think you have conversed with Mr. Ellis. You have 45 minutes. And if you have some minutes left over, you certainly can make a final comeback if you so desire. Okay.
Good evening, President Talbot and members of the board. I'm Emily Rogers, outside counsel for the Lower Colorado River Authority. With me is Lynn Clancy, the Managing Associate General Counsel and Senior Water Policy Advisor for LCRA. We appreciate this opportunity to address the board regarding LCRA's 8 groundwater permit applications pending before this board. In September 2018, after a lengthy public meeting, you may recall that this board referred LCRA's request for production and transport permits to the State Office of Administrative Hearings, or SOA, to conduct a contested case hearing on LCRA's request. Today, we are back before you with a proposal for a decision, or PFD, from the 2 SOA judges who conducted the hearing. After listening to 6 days of testimony and reviewing thousands of pages of evidence of all the parties, these judges weighed the credibility of that evidence, including the expert testimony and the science offered by each party, and concluded that LCRA has met its burden under Chapter 36 of the Texas Water Code. The PFD before you today recommends that the district grant LCRA's applications and issue the 8 operating and transport permits with some changes to the GM's original draft permits. LCRA's applications for production and transport permits for these 8 wells would allow LCRA to develop a groundwater supply in the Simsboro Aquifer below the Griffith League Ranch in Bastrop County. The permits would allow LCRA to produce up to 25,000 acre-feet of groundwater per year, subject to phasing requirements and other special conditions that are nearly identical to those contained in permits you've previously approved for recharge and gatehouse. LCRA's requested permits would authorize less production than allowed for those entities. In the case of recharge, nearly half that much. Though LCRA anticipates much of the groundwater to be developed could be used within the Lost Pines District, the recommended transport permits would allow LCRA to transport the groundwater to Travis County. The special conditions in the permit recommended by the ALJs, as mentioned, include phasing requirements that will control how LCRA is able to increase its pumping over time, which reflect consideration of aquifer conditions and actual water demand. The recommended permits also require LCRA to assist the district's monitoring efforts and require pump tests for each well that could be used to scale back pumping if local impacts are greater than anticipated. The protestants in this case want to make this much more complicated for you than it has to be. As I've mentioned, you've already approved permits for gatehouse and recharge with many special conditions that are nearly identical to those contained in LCRA's proposed permits. To treat LCRA substantially different by including further permit restrictions or arbitrarily reducing the permit amounts would be unreasonably discriminatory. This is particularly the case when you consider LCRA's request underwent a full contested case hearing with multiple parties and interests represented, unlike those other permits. You referred this case to SOA so that professional administrative law judges who do this kind of work every day could listen to the evidence, weigh it, and make a recommendation to you. The ALJs have done the hard and tedious work of evaluating the evidence and the law so that you don't have to. In fact, now that the ALJs have done this fact-finding, the Texas Water Code limits what you can do with those facts by expressly prohibiting you under Texas Water Code 36.4165 from reweighing the evidence and changing the fact findings of these ALJs except in limited cases. The board can only change a fact finding or conclusion of law if, one, the ALJs did not properly apply or interpret the applicable law, rules, written policies, or decisions of this board. Two, the ALJs relied on a prior decision that is incorrect or should be changed. Or three, there is a technical error in a finding of fact. As you listen to oral arguments, it is important to remember this because some of the parties are going to invite you to reweigh that evidence. To do so would be an error. It is directly contrary to Texas Water Code section 36.4165 and would result in reversal of the board's decision by a district court. Underpinning the ALJ's ultimate recommendation that you issue LCRA's requested permits are the following findings. One, LCRA's proposed use of the groundwater will not unreasonably affect existing groundwater resources or permit holders. Two, the limitations and conditions in the proposed permits will minimize as far as practicable the drawdown of the water table and the reduction of artesian pressure and will lessen interference between wells. The proposed use of the water will not unreasonably affect existing surface water resources. And four, granting the permits is consistent with the district's duty to manage total groundwater production on a long-term basis to achieve the applicable DFC. These findings are required for the issuance of a permit. And on all four of these issues, LCRA and the GM agree. Let's start with the ALJ's finding that LCRA's proposed use of the groundwater will not unreasonably affect existing groundwater resources or permits. As the ALJs noted, evaluating whether or not LCRA's proposed use will unreasonably affect groundwater resources and permits is fact-specific and involved issues related to the appropriate model, the relevant impacts to be considered, and what the evidence of impacts show. As a threshold matter, the ALJs found by an overwhelming consensus of evidence that the 2018 groundwater availability model, or new GAM, as opposed to the old GAM, is a better model to use to predict the effects of LCRA's pumping. LCRA's, the GMs, and recharges experts all agreed on this point. In fact, the ALJs noted that the GM's expert hydrologists said that the new GAM is the best available tool. The ALJ's finding that the new GAM is the best available tool in evaluating impacts cannot be altered by this board. The ALJs also concluded that the analysis of impacts must focus on LCRA's proposed pumping alone, not on LCRA's proposed pumping plus district-wide pumping. This conclusion is based on the Texas Water Code requirements, the district's own rules, and the board's previous decision in the City of Bastrop groundwater permitting case. The protestants in this case will encourage this board to reach a different conclusion on this point. You will hear a similar plea with respect to consideration of surface water impacts. The protestants don't want you to make a distinction between LCRA's impacts and the impacts caused by all of the pumping in the district because it hurts their cases. But a district court reviewing this case will not defer to the board's interpretation of law. A court will decide these issues independently. The ALJs are on firm legal ground on this issue, and the board should not be swayed by argument to the contrary. As the ALJs appropriately concluded, other than evaluating DFC achievement, all evaluations relative to permit issuance are for the impacts of the applicant's pumping alone, not in combination with other pumpers. In weighing the evidence on whether LCRA's proposed use will cause unreasonable effects on groundwater resources and permits, the ALJs considered the expert testimony of all the parties and found that the credible evidence weighed in favor of LCRA. The ALJs heard evidence from the LCRA's and the GM's experts who used the new GAM and, were available, considered specific well information for the protestants' wells to analyze the effect of LCRA's pumping of 25,000 acre-feet of groundwater on wells of groundwater users in the district. These experts concluded LCRA's pumping would not unreasonably affect existing groundwater resources or permits. The ALJs also heard evidence from the protestants' experts who relied on the old GAM in an attempt to argue that the anticipated impacts will be greater than what the new GAM shows. Weighing the evidence of the protestants as compared to LCRA's and the GM's evidence, the ALJs rejected the analysis of the protestants' experts and concluded that LCRA's proposed use of 25,000 acre-feet of water would not unreasonably affect existing groundwater resources or existing permits. These findings of fact cannot be disturbed or changed. Next, the ALJs considered whether conditions and limitations in the proposed permits would minimize, as far as practicable, the drawdown of the water table or the reduction of artesian pressure, or lessen interference between wells. After considering the evidence of all the parties, the ALJs concluded they did. Specifically, the ALJs found that the evidence showed that 1, LCRA's proposed wells meet the district spacing requirements. 2, LCRA will be required to conduct a 36-hour pump test for each well that will confirm groundwater characteristics in the area. 3, if necessary, the GM will be able to restrict pumping rates based on what the 36-hour pump tests show. And 4, the monitoring and phasing requirements will allow for future limitations of LCRA's pumping if impacts are greater than anticipated. It is important to note that the ALJs rejected Recharge's claim that the well configuration would cause unreasonable impacts through well interference, and rejected Aqua and Elgin's flawed analysis of impacts relied on the old GAM. Again, the ALJ's fact-finding and weighing of evidence on this issue cannot be changed. The next factor considered by the ALJs was whether LCRA's proposed use will have an unreasonable effect on surface water resources. Again, the ALJs concluded it would not. Like with the similar factor relating to the effects on groundwater resources, the ALJs correctly concluded the law requires the analysis to consider whether LCRA's proposed use would affect surface water resources and precludes an analysis of LCRA's proposed use combined with all of the district-wide current and future permitted pumping. Once again, while you will be invited by the protestants to reach a different conclusion, it isn't supported by the plain reading of the statute or district rules, nor is it supported by previous decisions by this board. The law requires you to consider LCRA's proposed use of groundwater when considering whether there will be an unreasonable effect on surface water resources. The fact is, the ALJs found no protestant in this case submitted any credible evidence that LCRA's proposed pumping alone will cause unreasonable effects on surface water resources. The ALJs found, at most, LCRA's pumping alone would result in about a 0.5% reduction in the annual average flow in the Colorado and its tributaries in Bastrop. The ALJs were clear that the permit cannot be denied on this basis. The ALJ specifically rejected as inappropriate environmental stewardship's expert use of the old GAM in a manner intended to overstate LCRA's potential impacts, and rejected the use of the surface water availability model in conjunction with the GAM to show adverse impacts. In contrast, the ALJs found the testimony of LCRA's and the GM's expert on this point credible, and concluded LCRA's proposed pumping will not unreasonably affect surface water resource. This conclusion cannot be overturned by this board. That said, the ALJs went beyond simply making fact findings on whether LCRA's proposed pumping alone would unreasonably affect surface water resources, and ventured into policy making that is reserved for this board. On this, LCRA disagrees with the ALJ's approach. Specifically, the ALJs found that cumulative pumping of all permittees in the district may cause losses to surface water to the groundwater system in Bastrop County decades from now. Based on this cumulative impact, the ALJs overstepped their authority and recommended that LCRA alone be required to help the district conduct surface water monitoring as a requirement of its groundwater permits. There's nothing in state law, the district rules, or its management plan that considers conditions under which groundwater permittees can or should be required to assist the district in expanding its groundwater network or surface water monitoring network to measure effects on surface water resources. The ALJs overstepped their authority here and ventured into the board's policy-making role when they recommended this requirement be imposed on LCRA. Under Texas Water Code Section 36.4165, the board may modify the ALJ's conclusions if the board determines that the ALJs did not properly apply or interpret applicable law, district rules, or written policies. In this instance, the ALJs did just that. LCRA is a steward of the river and is actively engaged in the study of groundwater and surface water interactions, including here in Bastrop County. LCRA doesn't object to surface water monitoring or paying its fair share to do that, but including it as a permit condition is not the way. This ad hoc approach would be a fundamental shift in the district's management policy and places an unreasonable regulatory and financial burden solely on LCRA for an effort to monitor cumulative impacts of all users. If the board thinks understanding the effects of district-wide pumping has on surface water is worthwhile, then such effort should be done on a district-wide programmatic level, not on an ad hoc basis through individual permits. The district should delete the surface water monitoring requirement from the proposed permits because it is contrary to state law, the district's rules and policies. The district can address cumulative impacts of district-wide pumping on surface water through its rules and management plan. Moving on to the requirement that the district consider whether granting LCRA's applications is consistent with the district's duty to manage groundwater production on a long-term basis to achieve the applicable DFC, the ALJs found the applications were consistent with this duty. As noted by the ALJs, the MAG is not a cap, but a management tool, and the evidence shows that the GM appropriately considered this factor. The recommendation is also consistent with prior decisions of this board. The ALJ's finding on this issue also cannot be disturbed. While the GM and LCRA reached resolution on most issues on which they disagreed going into the hearing, 3 areas of disagreement remain. They are whether this board should restrict the use of the bed and banks of the watercourse to transport groundwater, or whether it even has the authority to impose such a restriction. 2, whether this board can or should require binding commitments or contracts as a condition in the permit. And 3, whether or not this board can use a formula that evaluates compliance with a district-wide DFC as a means to limit LCRA's ability to move to the next phases of production under the permits. With respect to the bed and banks restriction, LCRA requested and the ALJs agreed to remove from the transport permits the restriction to use the bed and banks of the watercourse to transport groundwater. This conclusion rests both factually on factual and legal grounds. First, the ALJs found that the special provision was unnecessary because it is physically impossible to transport groundwater in a watercourse from Bastrop to Travis County. Why create a potential contested issue when the issue is moot? Second, the ALJs found, as drafted, the special condition is overbroad and there was no evidence that it accomplished the district's stated purpose of preventing waste. The ALJs found no evidence in the record that the GM had done any analysis to justify the blanket prohibition based on concerns about waste. In fact, the ALJs found that the water losses from the bed and banks transportation of water, even from Lake Travis to the coast, were significantly less than losses from existing users like Aqua's WSC transporting water by pipeline. Thus, the ALJs found the bed and banks restriction arbitrary and that exceeds the district's authority to prevent waste. Third, and most importantly, the ALJs appropriately concluded that the discharge of groundwater into a watercourse pursuant to a bed and banks permit issued by the TCQ is not waste as a matter of law. Waste requires the escape of groundwater, but under a bed and banks permit, the holder of that permit maintains ownership and control of the groundwater until it is used downstream, and thus the water has not escaped. The ALJs are on firm legal ground on this conclusion. For these reasons, the board should strike the bed and banks prohibition from the transport permits because this issue is moot and is beyond the district's authority. The next area of disagreement is the binding commitments requirement. The GM's proposed permits include a requirement that LCRA have a binding commitment to supply groundwater prior to the authorization of each phase of pumping. In addition, the GM's proposed permits would expire if LCRA did not have binding commitments on the 5th anniversary of the Phase 2 date. In the hearing, LCRA argued this requirement should be removed from the permits because LCRA believes it goes beyond the district rules, is not necessary to show beneficial use, and LCRA is an existing regional provider with a proven track record and existing binding commitments. While the ALJs believed that this district could require binding commitments, the ALJs found that the requirement was unnecessary because 1, LCRA had demonstrated the need for the water. 2, it is unlikely LCRA would not beneficially use the groundwater it pumps. And 3, there are other safeguards in the permit to prevent waste by LCRA. LCRA agrees with the ALJ's conclusions that the requirement is unnecessary. But in addition to accepting the ALJ's proposed changes to the draft permits, LCRA believes some further clerical corrections are warranted to prevent confusion, which are outlined in LCRA's exceptions and clarifications to the PFD. Such changes would be consistent with the ALJ's findings and would not run afoul of Texas Water Code Section 36.4165, which allow for changes to correct technical errors. In the alternative, if the board decides to keep the requirement or does not make the changes I just outlined, LCRA requests that the board find that the binding commitments that LCRA already provided to the district meet the requirements of the permits, and therefore LCRA has already complied with this requirement. This legal conclusion is consistent with what is allowed under the Texas Water Code. Moving on to the third and final area of concern. One component of the proposed permits is the formula that informs on whether LCRA may move to the next phases of production in the permit. If the board retains the formula, LCRA and the GM have agreed to changes that make the formula more workable. Those changes are reflected in the revised draft permit recommended by the PFD. However, LCRA remains concerned that the approach imposes an unfair and unreasonably prejudicial burden on LCRA and other permittees that are subjected to an earlier version of the formula. Specifically, the effect of the formula is to place DFC compliance, which is a district-wide standard, on the shoulders of a handful of permittees that are subject to the formula. And it has only been applied to new large permittees that also seek to export groundwater. This is discriminatory, and such requirement is contrary to state law. It is also noted that the formula approach was a negotiated provision in the 4-star and now gatehouse permits, and later included in recharge permits without protest. Voluntary and uncontested conditions included in prior permits, like this formula and mitigation requirements, do not render them legally defensible as special conditions in future permits. LCRA requests that the formula be removed because it places a higher burden of DSC compliance on only those permittees that are subject to the formula. I'm going to close by going back to the beginning of my remarks and reminding you of where we are in this proceeding. As board members, the decisions before you are not nearly as hard as the protestants are going to try to make them. The ALJs have already heard all of the evidence and have done the fact finding you need to reach a decision. Of course, you will evaluate whether you think the ALJs properly applied or interpreted the applicable law, the district's rules, written policies, and prior decisions. It is also important to remember your charge is set out in Texas Water Code Section 36.0015. Groundwater districts protect private property rights of protestants, but also those of applicants like LCRA. They are charged with balancing conservation with the development of the groundwater resource that is needed to meet the needs of this state, such as the demonstrated needs LCRA intends to satisfy with these permits. And groundwater districts are expected to use the best available science during the process, which the ALJs found reflected in the expert testimony and evidence offered by LCRA and the GM. With that, LCRA requests that this board adopt the PFD, including the findings of fact and conclusions of law recommended by the ALJs, as modified by their responses to exceptions, and as LCRA has requested today, and issue the permits consistent with those findings. Thank you. That concludes my remarks, and I reserve the remainder of my time for rebuttal. Thank you.
Before we move on, does the board have any questions for the representative for LCRA? Go right ahead.
Could you please, I can't hear you with the mask and everything, it's hard. It may not be on.
Is this better?
Just a little.
Is this better?
That's a lot better.
LCA wants to take pristine water and mix it with surface water. What end user will accept this?
You've asked, LCRA wants to take pristine water and mix it with surface water?
Yes, ma'am.
I don't believe LCRA is requesting that it mix it with surface water, because any transport would be to Travis County, and you can't transport groundwater uphill to Travis County.
Did you say something a while ago about waterways, abandoned waterways?
Right. In the permit, in the transport permit, there is a restriction on the use of the bed and banks of the water course to transport groundwater. LCRA amended its request to only ask for the water to be able to be transported to Travis County to eliminate any concern that LCRA was going to use the bed and banks of a water course to transport water. Nevertheless, LCRA thinks that requirement is an illegal requirement. And that's why we are asking for that restriction to be removed from the permit. But we are not asking to use the bed and banks to transport the water at this time, because you can't use the bed and banks to transport it to Travis County.
Thank you. Thank you.
Is there any other board members with a question? If not, thank you, and I'll remain the rest of your time for rebuttal. I would just like to ask if at the end here, if you would mind submitting your written and presentation materials for the record for us.
We will do that. Thank you.
You bet. Okay. Who do we want to call?
Have the protestants reached an agreement on who's going to go in what order and how much time each going to have, or each going to split it equally?
On the order, as well as the time.
Okay.
We're each going to take up to 10 minutes for the first 4, and anything remaining, our fifth speaker will be able to use that extra time.
Okay. So who's first?
Who's first?
This would be,
Mr. Grissom.
I'll be first, Don Grissom, on behalf of the
Thank you.
Brown landowners. Thank you. Again, I'm Don Grissom on behalf of the Brown landowners, and as the protestants, and we represent a group of the protestants, no, we're not trying to make this complicated. We believe it's very simple. And no, the ALJs that sat through this hearing, contrary to what they said, were professionals who do this every day. Unfortunately, what we found out on the first day was this was the first time either of the ALJs had ever heard a water case. So talk about being a fish out of water, they were. So that's what we were faced with. And we did, council and the parties went through 6 days, long days of hearings and evidence, all of which was virtually discarded and not referenced in this PFD. And, you know, when you've reached a conclusion, why let the facts or evidence get in your way? Yes, I can do that. Is that better? Okay. Here, LCRA submitted an application. We agree they filled in all the blanks. They checked all the boxes. They probably signed it with the correct color of pen. And then, as the basis and support for that application, they submitted a model, a prediction based upon the GAM. And we agree that the second GAM is the best GAM. No one has criticized that. And why is it better? Because more regional data was provided than what was in the first GAM. Everybody agrees, every expert agrees, every party agrees, the more data you have, the better the information, the better you can make a decision. That's why the second GAM was created, because there was more data available, which made it better. It is not the best available science. It is a tool. It is referenced as a tool. It is given to you as a tool, not as a deciding factor. And here, that is all that has been relied upon, is that tool, a prediction. And we all know how predictions are. You know, the captain of the Titanic predicted that that was a ship that can never be sunk. On his maiden voyage, it was a catastrophe. We can't have that catastrophe here, and that's what we're trying to head off. If you look at the evidence, and that's what we're talking about, the evidence. Every expert, bar none, said with unqualifiedly that the GAM was not suitable for predicting local impacts. And so what do? They look at totally regional impacts. And all of their studies, all of their testimony about if you look at LCRA alone, if you look at us by ourselves, and you look at us, what happened to the regional impacts, it's marginal. Your duty as board members, your charge is to protect the water rights, property rights, the water, and conserve the water in this district, being Bastrop and Lee County. That was not addressed. Why was it not addressed? Because they didn't have the information in the GAM to do that. Now, was that information available? Yes, it was. Where was it available? It was available in the prior work that LCRA themselves had done, hired experts back in the 90s at the Lost Pines when they drilled some other wells. And Mr. Hardin there, had determined, and his report was part of the evidence, that the maximum reasonable amount of acre feet that could be produced was 10,000 feet. That's actually Mr. Saunders in his report in 1998, hired by LCRA. 10,000 acre feet by a hydrologist who did actual drilling, actual pump test, actual work in the field. Fast forward to 2016, they hired Mr. Hardin to analyze what is a reasonable amount. He determined, based upon his work as a hydrologist, geologist, field work, that the maximum reasonable amount of yield would be 10,000 acre feet. That's what they submitted to the U.S. Fish and Wildlife, saying, here's what we propose to do. We're proposing to buy the water rights at the Griffith Ranch. And we believe we can reasonably produce 10,000 acre feet. They did it because of the Houston toad issue. Now, that's the only two sources of actual field work, actual field data, actual science that was testified to or put into evidence at this hearing. That's all that you should rely upon, because that's the max. So, what do? They just disregard that completely. Why? Because they thought they needed more acre feet. Because when you fast forward through the evidence that was presented and the emails are, well, let's prepare some charts. Let's see what, let's see what the effect is if we have 10,000 acre feet on the desired future conditions. So they did the charts. They failed. Let's see what happens at 15,000 feet. They graph their charts. They fail. Let's see what they do at 20,000 feet. They graph their charts. They fail. All this is part of the record. They fail every time. And why? Because you can't pump that much water out of the Simsboro without affecting the desired future conditions. We know this from experience. You can look up, and it's part of the record, it's part of the evidence, and we want to talk about the evidence. At Alcoa, how many acre feet were they allowed to pump? 23,000. What did they do? They dewatered every aquifer above the Simsboro, every one. They destroyed every well above them. They dewatered the Simsboro to the extent that they could mine. Okay. That was off of 23,000 acre feet. Those wells have not recovered to this day. That's part of the record. Wells are 18 miles away, have not recovered to this day. That's part of the evidence. Why do we think that just a few miles up the road that we're any different here? Because we're not any different here. That's something that you can bank on. That if it happened there at 23,000 acre feet, what do you think is going to happen here at 25,000 acre feet? The same thing. So, with their charge, they decided, okay, well, we need to submit 25,000. Now, there is no hydrologist, no geologist that testified that said that based upon the geologic conditions, the hydrologic conditions, that we can reasonably pump 25,000 acre feet. That is not in the record. It is not in the record. So what they do, they say, let's submit a proposal for 25,000 acre feet, and this is in their emails, because we believe that we will only get 60% of that. And we could live with 60%. So put together a proposal, but you got to exclude all other pumping sources. You got to exclude all other permits. You got to exclude all other wells so that the chart shows only LCRA. Only LCRA. And make that look good and give that to them. And that's what they did. And that's how we came up with that number of 25,000 acre feet. It was not based upon any science. Unreasonable impact. That is a decision for this board to make, not the ALJ, and certainly not their expert who said, well, I've decided that, okay, so what if your well goes dry? His words were, that is your fault. Because you didn't anticipate that someone like us would come in later, 10 or 15, 20 years later, and drill and take that water down. That's his words. That is your fault. It's in writing. It's not an unreasonable impact if your well is now degraded and you can't use it. It's your fault, not ours. None of that, he never admitted to any unreasonable impact, because in their mind, whatever they do is not unreasonable. Unreasonable impact is a matter of law for you to decide. There's no standard. We're asking you to put in some standards of what is an unreasonable impact. Is the loss of Mr. Weir's well here, is the loss of his well an unreasonable impact? Sure it is. Is a degradation of the water quality an unreasonable impact? Of course it is. They would have you believe that it's not. It is up for this board to determine what is an unreasonable impact. If you grant this permit as offered, as put out there, if someone were trying to set the lowest bar possible for permits, this is it. There are no standards here. If you produce a model and based off of a GAM, we're golden. We don't have to do anything else. We believe that this board has higher standards than that. We believe that this board wants more for this district than that this board wants more for the citizens of Bastrop and Lee County than that we have a higher bar. We want development. We want to preserve our rights. We want to preserve our water. That is a balancing, but you got to set a higher bar than what we are here. This permit should be denied, at a minimum, sent back to the ALJs to say, you need to look closer at the evidence that was presented on unreasonable impacts, on the science of what science was presented by the other parties. Thank you.
Okay. Go ahead. Does the board have any questions for Mr. Grissom? No questions, and we'll go to the next person.
Yes, Mike Gershon with the law firm of Lloyd Gosselin, Rochelle and Townsend. I'm here on behalf of Aqua Water Supply Corporation. You know our general manager, Dave McMurray. He's to my right, and he would like for me to pass along to you that our board considers this matter, this case, to be priority number one and a very serious concern that they continue to monitor. Sorry that we couldn't have our board members here today. They've paid close attention to it. If LCRA's application is granted, as proposed by SOA, Aqua Water Supply Corporation stands to lose $10 to $20 million in well and infrastructure and water rights. Those are impacts directly to Aqua. As a nonprofit retail public utility, this is a serious problem. The stakes are huge for Aqua Water Supply Corporation. Aqua Water Supply Corporation recognizes that the stakes are huge for many, for dozens involved, including the board and its constituents. I also work for other utilities and other groundwater conservation districts. I'm often in your shoes on behalf of my groundwater districts, trying to develop a legally defensible decision on controversial permit applications, similar to this. What SOA has proposed is not legally defensible. I agree with comments that Mr. Grissom said about the inexperience of very competent judges, but the inexperience of the judges on groundwater rights issues. On the sixth day, as we went off the record, the judges asked for extra briefing about what they just heard so they could better understand what they needed to deal with in developing their proposal for decision. So what to do with the proposal for decision? I would say that if there were to be an appeal of SOA's proposal, it is arbitrary and capricious. It is not supported by the evidence in this record. Mr. Ellis will spend time with you evaluating that standard, the substantial evidence review, and what you all want to do in developing a legally defensible decision. And I would contend that the proposal for decision does not meet that standard and has problems if you were to endorse it. The reason is that SOA did not give substantive attention to your two permitting criteria that are set forth in your Rule 5.2. It's 5.2, D2, and D9. Both criteria require consideration of local impacts, an assessment of unreasonable effects on existing permit holders, number one, and number two, a look at well interference. This district was in a similar situation after the SOA hearing on the NDOP recharge application, when SOA did not adequately cover the district's interest in the needs analysis. This board remanded with instructions to SOA to take a harder look at that issue. And the issue was need for water. So we have a similar deficiency in LCRA's case, and it isn't about the issue of need. It's the issue of this local impacts and the D2 and D9 criteria in your rules. SOA has not provided you with the fact findings that you need to be well informed and to make a recommendation that allows you to make a legally defensible decision. And the deficiency is all about those two criteria. This trial could have been a day. It could have been 2 days. It was a full 6 days. This week-long trial was all about local impacts. Before we even started the hearing, this board requires, and you had SOA look at the issue of how you get standing, how you establish what we call a justiciable interest, whether or not you're affected by an application to even participate in the hearing. Every protestant pointed to their own respective interest, which involved local impacts. Every protestant put on substantial testimony about local impacts during the hours and hours of testimony and the mountain of paperwork and filings. So for your hearings process to make sense, the judges needed to pay better attention to your two criteria. But here we are today, trying to make sense of the recommendation. What is apparent is that LCRA believes that they get a permit if they can check two boxes, and not the two boxes I'm talking about with your criteria. First, if they meet your minimum well spacing requirements and their modeling results, which look at average drawdown within a 1,500 square mile area that's your district boundaries, then LCRA's pumping by itself if it doesn't bust the desired future conditions, then they're clear and they get their permit. Well, Aqua knew that. Aqua knew about the minimum well spacing requirements, and we looked at the modeling. We all knew that. What LCRA is proposing is, frankly, we didn't even need a hearing to waste our time looking at local impacts, because that wasn't what their focus was, obviously. And they sold that hard to these two judges at SOA. As we mentioned, our judges did not have the experience with groundwater rights. They did write an 81-page proposal for decision, but only about 4 to 5 pages even cover the unreasonable effects and well interference issues that you're going to hear, that you've heard from Mr. Grissom, and that I'm talking about. And those pages are even a superficial coverage of it. They conclude and they agree with LCRA that regional scale modeling tools can be used instead. So Aqua would respectfully request that this board consider the precedents like you followed in the recharge case by remanding to SOA, and that you work with Mr. Ellis to draft guidelines for the judges to evaluate those criteria, expand their analysis, and prepare more findings on those criteria. If you do not remand, then LCRA did not meet its burden. And outright denial is an option because LCRA didn't meet its burden. That said, Aqua believes that the record is sufficient to support granting an application in the amount of 8,000 acre feet without prejudice. LCRA can request more in the future if after pumping that amount, they believe the science indicates that more is available without causing unreasonable effects. Many of you know that Aqua used to control the same water that LCRA is requesting permits for. Aqua put into evidence its own due diligence when it controlled those rights, and its conclusions years ago was that you could produce about 6,000 to 8,000 acre feet. The detailed testimony that you can read in the closing arguments and in the record before you reflects that, and our experts' opinions about that. So your general manager's position. Mr. Totten seems to have tried to follow the board's precedent, as you would expect him to do, the precedent from other large volume controversial applications, Bastrop, the NDOP recharge application, and the four-star cases. Totally understandable, makes sense. It's reasonable that he wouldn't want to get ahead of you on a case as important as this one. But those cases are distinguishable. And in every one of those cases, ultimately, whether it was on the front end or after litigation or during settlement, the local impacts issues were addressed. There is no question that recharge's application unreasonably affected Aqua and dozens of other well owners. But for recharge's willingness to voluntarily mitigate, this board would have been in a situation to have to deal with those localized impacts. That's how we dealt with it, but that's distinguishable. LCRA isn't proposing to do what Recharge offered to do. So if you grant the application as so recommended, it does set a different precedent. It's different from what you've done with the other cases. You'd be giving a nod to LCRA's and SOA's position that you just got to check the two boxes regarding minimal spacing requirements and regarding looking at average drawdown throughout your district over a 1,500 square mile area. To take that position disregards the very reason for a hearing. If you wanted to go that route, Chapter 36 offers you the ability to do permitting by rule. In fact, your Rule 5.2C is permitting by rule. If you're asking for 50 acre feet or less, or maybe less than 50 acre feet, you don't have to go through a hearing and all this process. You all could evaluate to go another route with large volume applications, but that's not what you've done. You all have a hearings process to allow for those impacts to, I'll conclude. The protestants and Aqua put on experts who focused on these impacts. Aqua's expert hydrogeologist, Mike Thornhill, looked at the GAM results also. He also testified about the next steps you needed to take to use that information in a site-specific localized way. In closing, Aqua appreciates the position that you're in. We believe that your decision would benefit from a remand so that you can make a more well-informed, legally defensible decision focusing on these two key criteria. Frankly, those are the two criteria that your protestants get their standing on, looking at those localized impacts. So we believe you have options. You can deny the application because LCRA did not meet their burden, or, as Aqua is proposing, granted at 8,000 acre feet, which would not cause an unreasonable effect. I don't spend time this evening on special permit conditions. We've discussed bifurcating presentations and possibly having another opportunity for argument. Aqua would be pleased to visit with you more about the special permit conditions. Appreciate your attention. Thank you.
Okay, thank you.
I pass.
Okay, any questions for Mike? It's a long look all the way down through there, so I don't want to miss anybody. Okay. Who is going to speak next?
That would be me.
Okay. State your name, please.
Good evening, Mr. President Talbot and board members. My name is Marissa Perales, and I'm here representing environmental stewardship. As you may know, Steve Box is the president and director of environmental stewardship, and he asked me to convey tonight that he would have very much liked to have been here participating in person, as he did during every day of the hearing regarding this LCRA permit application. But because of concerns about COVID, the potential health impacts on him, his family, the board members, and all of the parties here, he decided it wasn't advisable or safe for him to be here tonight in person. So while we're all appreciative of the opportunity that the board has provided for participating via Zoom, we also want to acknowledge that conducting this board hearing in this manner has an impact on the public's ability to fully participate here. And accessibility is a real issue. And we just want to make sure that that's on the record, and that our preference would have been to wait until we could all safely gather in person to participate in this hearing. So with that, I'll turn to our issue. And as you probably gleaned from a review of the PFD and our written arguments, environmental stewardship has focused its participation in this matter primarily on the issue of whether LCRA has satisfied its legal burden of demonstrating that the proposed use of its water will not unreasonably affect surface water resources. LCRA is not entitled to its requested permits unless it satisfies this legal burden. And we agree with the arguments that have been presented by the other parties in this case, and that you will hear from the remaining protestants. But our comments tonight will be again focused on that legal issue, on whether the LCRA met its burden of showing that there will not be an unreasonable impact on surface water resources. Environmental stewardship has maintained and presented expert testimony and evidence demonstrating that LCRA's proposed pumping will indeed have an unreasonable impact on surface water. And the ALJs in their PFD essentially agreed with us, explaining, and I quote, "The GAMs show potential impacts to surface water resources caused by LCRA and district-wide pumping." General Manager's testifying expert, Dr. Hutchison, also agreed with us. And it's his graphic that I have here on the screen that I'm sharing. And this is from the report that he presented during the hearing, and it shows that the blue line is the baseline from the GAM, and the red line is the baseline plus the LCRA pumping. And as you can see, during the year about 2040, we get below, it becomes a losing stream, basically. So Dr. Hutchison's graphic and his predictions were consistent with our experts' predictions, with George Rice's predictions. He prepared a similar graphic that showed the same trend. And even Dr. Young, who testified on behalf of LCRA, his modeling demonstrated, again, the same trend, that we can expect to see impacts on surface water resources if LCRA's pumping is added to the baseline. He also admitted very candidly that he's not an expert, doesn't have the qualifications or the expertise to opine on the reasonableness of the impacts that are predicted on the surface water resources because of LCRA's pumping. So all three experts, LCRA's, the general managers, environmental stewardships, they all saw a similar trend, and that trend is that the proposed pumping will reduce flows in the Colorado River. And Dr. Hutchison even explained in his report that in about 2040, I quote, "The surface water system begins to act as a recharge to groundwater." These predicted impacts were all based on the best available data. And to be clear, we all use the same GAM with basically the same pumping files to determine LCRA's impacts on surface water resources, not cumulative impacts. And this was, again, based on the GM's GAM. All three experts, Dr. Young, Dr. Hutchison, Mr. Rice, acknowledged that the GAM could not quantify the impacts to surface water with any real precision, but it still remains the best available science for purposes of looking at the impacts on surface water. And that's why we need field data to confirm whether those predictions are accurate, to quantify what we're seeing in those GAM models. So in short, as Dr. Hutchison again explained, it is unreasonable to summarily dismiss the potential for impact on surface water resources that would be caused by the requested permits. Based on this best available science, LCRA has not demonstrated that it satisfied its legal burden that it was required to satisfy in order to obtain its requested permit, even with the phasing approach that it has proposed. So we agree with the other arguments that have been presented to you today. And we agree with the argument that you just heard from Mr. Gershon, that if you determine that a permit should be issued tonight, then it should be limited to phase 2, which is the first pumping phase, the 8,000 acre feet. We would agree that if it were limited to 8,000 acre feet, it must still include a monitoring well system so that the district, the general manager, the board, the LCRA, and all of the affected parties can evaluate the impacts of the pumping on surface water resources based on that field data, and then determine whether that field data is consistent with the modeling predictions. If LCRA later determines that it needs to amend its permit and request more water, then the data that's been collected from the monitoring well system will inform the general manager, the board, LCRA, and all of the affected persons whether an increase in the permitted pumping can be achieved without unreasonably impacting surface water resources. The evidence in the record supports this approach. Indeed, it mandates this approach, as explained again by Dr. Hutchison in his testimony, and I quote again, "All I can say is that given this application and the material that was provided to me, that the first 2 phases, that's the 8,000 acre feet, that the first 2 phases, there will be no unreasonable impacts. Here we're talking about pumping that's so much larger than has been experienced in the past. You're outside the bounds of the calibration of the model." So basically beyond the 8,000 acre feet, he's saying, we're talking about something that's much larger than we've experienced before. And again, he opined that it would be he opined that it would be unreasonable to dismiss summarily the potential for the impacts on surface water resources. Thus, if the board determines that a remand is appropriate, as has been suggested, then we urge the board to include among the issues to be considered for remand the following: determine the process and timeline for developing a surface water monitoring well system. The details of this monitoring well system need not be spelled out in the final order, but we must have a commitment that a monitoring well system will be developed and implemented by a time certain and with input from affected persons. There's no need to change any of the findings to accomplish this. This would be consistent with what is in the PFD. And in fact, incorporating a monitoring well system is within your discretion, and it is necessary in order to comply with your statutory obligations and responsibilities of ensuring that any pumping permit does not have an unreasonable impact on surface water resources. So with that, I am happy to answer any questions.
Do we have any questions for environmental stewardship? I just would like to say, again, if you've come with written comments and presentation material, if you would provide them up front here so that can become part of the record, it would be appreciated.
I'll do so, thank you.
All right, who's number 4?
Good evening. My name is Cole Ruiz. I'm with the law firm of Lloyd Gosling, Rochelle, and Townsend. I'm here today on behalf of the city of Elgin. Today, I have with me Mr. Tom Mattis, the city's city manager. The city of Elgin, as you know, is located just north of here on the edge of Bastrop County. And our municipal water utility system provides water service to around 11,000 people. Elgin's sole source of water for its utility customers is groundwater produced from Elgin's own wells, and the vast majority of which comes from the same formation that LCRA has targeted for production, the Simsboro Aquifer. As such, Elgin will be significantly and unreasonably impacted by the groundwater production authorization LCRA is seeking. To address these unreasonable impacts, Elgin is requesting that this board grant LCRA's permit at a reduced amount, subject to a maximum authorized production of 8,000 acre feet per year. Elgin also recognizes the collective interests of the parties, including LCRA and Lost Pines GCD, to make a decision that is both legally and scientifically defensible. To that end, Elgin would also support a remand of this proceeding back to the State Office of Administrative Hearings to more thoroughly address localized impacts to Elgin's and other protestants' existing wells and permits. The decision before you today can be boiled down to one question, which this board is duty-bound to answer under Section 36113D2 of the Texas Water Code and District Rule 5.2 D2 and D9. Will the proposed permit authorizing 25,000 acre feet of Simsboro groundwater unreasonably affect existing permits? The record is replete with evidence that the answer to that question is yes. From the outset, LCRA's request for 25,000 acre feet was ambitious. LCRA is a sophisticated and prudent business-minded organization that can afford to hedge its bets. And that's what happened here. LCRA's approach to business in this case was to first see what it could get away with by requesting an exorbitant amount of groundwater, and then only after the uproar of party protestants and this board's referral to SOA to defend its request with an analysis that purposefully ignores localized impacts. In fact, the record suggests, and I'll refer you to that, Mr. John Hoffman, LCRA's Vice President of Water, testified that it was LCRA's desire to ensure it receives the full benefit of LCRA's investment and to use its groundwater rights as allowed by law. Unfortunately, for the city of Elgin, the law requires that such decisions be based on the best available science, not the applicant's most convenient science. In a contested case such as this one, the burden is on LCRA, the applicant, to provide sufficient information in its application, supporting documents, evidence, and testimony to demonstrate to the board that its request for 25,000 acre feet does not unreasonably affect existing permit holders. It's worth noting that LCRA's own experts testified that there will be impacts to the protestants resulting from LCRA's production. The fundamental disagreement between LCRA and the protestants is the classification of those impacts as unreasonable. There are no statutory thresholds that define which impacts are reasonable and which are unreasonable. LCRA would have this board believe that any amount of production that does not bust the mag cannot unreasonably impact existing permits. That interpretation fails on two fronts. First, the groundwater availability model from which the mag is derived is a regional model that does not account for localized impacts to existing permits. And this particular GAM in question notes these limitations in a disclaimer. In order to meet the statutory standard of best available science, the limitations of the GAM must be offset by site-specific data. For the sake of time, I'll refer you to Mike Keister's record testimony and his four-step process for calibrating the GAM to localized impacts. The second reason LCRA's convenient science theory fails to satisfy both Chapter 36 of the Water Code and the district rules is that it would set a precedent that this board grants every application for a production permit, no matter the quantity of water requested, so long as it comes in under the MAG. The implication is that the protestants' sole remedy is to apply for more permits in order to protect their existing permits. That type of thinking incentivizes a race to the bottom. And it's precisely why the legislature empowered groundwater districts with the authority to manage the resource. It is the directive of the legislature to use the best available science in order to protect property rights and to balance the conservation and the development of groundwater to meet the needs of the state. In closing, I'll reiterate a point already made. LCRA bears the burden to show that under the best available science, this production will not unreasonably impact Elgin's permit. LCRA hired some of the best consultants and experts in the field to show that it can meet that burden. But where LCRA fell short is in directing its experts to ignore localized impacts to existing permits. Elgin picked up the torch and completed the analysis by marrying the GAM with site-specific data. The science is clear, and the record shows that impacts to existing permits amount to a level of unreasonableness. What are those unreasonable impacts to Elgin? A reduction in the capacity of its existing wells, which it relies on to serve its growing population, and an impaired ability to meet current demand without additional water supply, an impaired ability to provide continuous and adequate service to its existing utility customers, and a significant economic loss, not the least of which is an estimated $2.3 million for a new well. For the city of size of Elgin, that cost can be crippling. The city is grateful for the opportunity to have its concerns heard today and is equally grateful for the time and the attention of this board. Thank you.
Before we continue, does anyone have questions for the city of Elgin? If not, you have 11 and a half minutes available for, Paul wants to.
President Talbot, you ready?
Yep.
Paul Terrell, and I'm here on behalf of Recharge. Thanks for being here, and I appreciate the board for being here. The basic problem here from our perspective, and I'm usually at the table where the LCRA is the applicant's counsel, and I don't blame the lawyers for this. This is really the agency's fault. They filed a slipshod application, and they didn't prove up the resource. And I'm going to talk about that, and you are not handcuffed. They suggested that you're handcuffed on what you can do here, and the answer is no, you're not. And the reason why is there's some just basic failures of fact. I want to start by pointing out the well field configuration. These green dots that are jammed up against the property line here of the Griffith League Ranch are LCRA's proposed wells. Look at the spacing of that. What they did is, your rule got amended not too long ago, and this is a policy issue that you guys can look at. They gamed the system and put all of these wells this close together. On other high volume applications like recharges, these spacings are 5,000 plus feet apart, and that's because this district wanted high volume applications to have a spread out well field to minimize the impact. That's not what they did. They put it as close to Recharge's wells as they could right here, wells 1 and 2, and then they put all of the other ones just boom, 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 and then right up against the property line. So when you're thinking about the interpretation of your rules, which that's your call, that's not their call, and that's not the ALJ's call, that's your call. You get to determine whether that is a legitimate use of well spacing under your rules. What happened in the PFD was very surprising to me. It is probably due to the ALJ's inexperience, but it is astonishingly thin on the most important issue, which is localized impacts. All they did really is compare the old GAM to the new GAM, which is, I would call it a fake controversy. The issue isn't whether the old GAM or the new GAM is better. The question is the GAM, which is all that LCRA ran, is the GAM good enough? I respectfully submit that the answer to that is no. And I want to read to you from the GAM how it describes its own limitation. So, to be clear, I'll read it in seconds. So, to be clear, when you're considering well interference between LCRA and, for instance, Recharge's permitted wells and unreasonable impacts when LCRA only ran the GAM, listen to this. This is in evidence, and this is from the GAM. Limitations of model applicability. The purpose of the TWDB Groundwater Availability Modeling Program, and that's the GAM, is the development of models to determine how regional water availability is affected on a large scale by water resource development. Except for near the Colorado and Brazos River alluvium, which by the way doesn't apply here, the model was developed at a grid scale of 1 square mile. So in other words, every grid is 1 mile in each direction. Or to put it in the context of this, a grid square would contain more than one well because of this spacing. Like this grid square right here would have multiple LCRA wells in it. Now back to the GAM limitation. So this model was developed at a grid scale of 1 square mile. At this scale, models are not capable of predicting aquifer responses at specific points, such as at a particular well. So in other words, the GAM is telling you it cannot predict what will happen between well for recharge and well for LCRA. It's telling you that. I continue on. The groundwater availability models are accurate at the scale of tens of miles, which is adequate for understanding groundwater availability at a regional scale. Questions regarding local drawdown to a well should be based on analytical solutions, such as TTIM, or a modification of the groundwater availability model that includes a refined numerical grid. Now, that's Aqua's exhibit number 10. And let me tell you, because this is an absolutely key fact, they only ran the GAM. They did not run an analytical model. They did no analysis whatsoever of localized impacts between their proposed wells and Recharge's proposed wells. They didn't do any analysis of any of the Brown landowners either. They did. So you heard them talk about no evidence. There is no evidence of localized impacts. All they did is they ran the GAM, and the GAM tells you it cannot be used for localized impacts. So when they talk about how you're handcuffed and how you can't do anything contrary to the PFD, that is not correct. Where there's not evidence on a point, you can look at that PFD, you can look at the record and say, that is not correct as a matter of policy and as a matter of evidence. There's no evidence to support that. And the policy is wrong because of the well spacing. And I asked this board to consider, if you looked at that 81-page PFD, did you have any idea that that's how they did their well field, that that's how they configured it? I mean, that's one of the things that's so frustrating about what came out of that 6-day hearing is we spent days talking about that and cross-examining their witnesses, and then like nothing from the hearing showed up in the PFD. So I want to give you 3 critical facts. The first one is the one that I just went over, and that is LCRA relied solely on the GAM to analyze localized impacts. The second, and this is hard to believe that it wasn't covered by the PFD, we briefed it extensively, and I cross-examined LCRA's expert, Dr. Young, about this while he was on the stand, and that is the GAM assumptions are wrong for the Griffith League Ranch. This is not a matter of my opinion, it's fact. So, the Griffith League Ranch, which is covered by this orange outline right here, if you go look in the GAM, and this is true for both the old GAM and the new GAM, it has assumptions about transmissivity. And it's on for each 1 mile grid square. And for transmissivity, the GAM assumed that the transmissivity was roughly twice as much as the site-specific data that had been developed for that property. So here's what's crazy about it. Dr. Young is the author of the GAM, and I asked him about the data being wrong, and he acknowledged that the GAM just uses assumptions. The site-specific data for the GAM on Griffith League Ranch is wrong, and it's wrong by it's a factor of 2. And so the significance of that is when the transmissivity is a lot lower, half of what the GAM assumed, what that means is that causes the drawdown to be twice as bad. So the localized impacts that they didn't consider with the local model, even the GAM numbers are wrong. The site-specific data is just dead wrong. The third fact that I want to talk about is that because there was no site-specific testing done and there was no analysis done, there is literally no evidence in the record about what the impact will be on recharges, permitted wells, and on the other wells as well. You know, I'm here representing recharge, but this board represents the entire district, and there are other landowners that have Simsboro wells that could potentially be impacted, and they did no analysis of it. So, President Talbot, how much time do I have left, please?
Couple of minutes.
Okay. This board is faced with a decision, and I think that the important thing for the board to think about is what you're going to do here is setting precedent. And so when recharge came to this district, it drilled multiple test wells. LCRA drilled none. It proved up the resource by running both the GAM and running analytical solutions. And then also, because we know that that well field, even though it's spread out, it is going to cause some drawdown of artesian pressure, had in a friendly neighbor, good neighbor, mitigation for both local wells and for aqua. LCRA, none. So they came in, they're asking for 25,000 acre feet, no on-site testing. They only ran the GAM. They did no analysis of localized impacts, and they're not doing anything to mitigate even Bastrop with 1/10 of the amount that, less than 1/10 of what LCRA has applied for, did on-site testing, ran the GAM and analytical solutions as well, and mitigation. You should require more of LCRA. They're a public governmental entity. They filed a slipshod application. They didn't prove up the resource, and they can and should do better. They suggested that you should remand this to SOA. I'm not saying you can't do that. I'm respectfully suggesting that they should have done better. You just ought to deny it. Happy to answer any questions you've got.
Does the board have any questions for Mr. Terrell? Sure, correct. Correct.
And just for your convenience, I'll pull it back over here so everybody can look at it if they want to.
If y'all want to go look, just kind of stand in line and keep your social distance.
Paul, I'm assuming that that map is in part of the overall record?
Yes, it's recharge 13.
Recharge 13, thank you.
Is there any other questions for Mr. Terrell? If not, the general manager, you did use up, I'll let you go over a little bit, but you all were very respectful of time and had your presentations well put together, and I thank you for that. So Natasha, I guess you're here representing the general manager? Okay. Just go ahead and state your name for the record and go on.
Okay. Good evening, President Talbot and members of the board. My name is Natasha Martin, and I'm here on behalf of the district's general manager, Jim Totten. Mr. Totten is attending tonight virtually. If the board determines to issue a permit, the GM recommends modifications to the PFD concerning how the PFD negatively impacts the draft permit on 1, binding contracts or commitments, 2, monitoring wells and the trigger to move between the phases in production, 3, the transport condition on waste, and 4, technical errors and internal inconsistencies. I won't go back over these factors. LCRA reviewed the board's authority to make changes to the draft permit or the PFD, but the GM is asking you to reject certain conclusions of law due to improper application of the law or rules or the presence of technical errors. Like the ALJs, the board has to weigh the evidence. The board is to give evidence the weight it deserves, and it is not expected to make findings on all of the evidence. So let's talk about what the ALJs got right. The ALJs properly included findings that the draft permit satisfied the district's statutory obligations. The ALJs generally track the criteria upon which to grant or deny an operating permit or transport permit under Chapter 36 or the district rules. Based on the evidence, the ALJs properly found that the GM's revised draft permits contain sufficient terms to lessen well interference. The draft permits, production limits, requirements for pump testing and monitoring, and curtailment provisions allow the district to manage groundwater to meet demands on a sustainable basis and to achieve the DFC. They also found that the new GAM is the right tool to evaluate impacts when issuing permits. They also found that LCRA's proposed use of water would not unreasonably affect water resources or existing permit holders. The MAG or the DFC are not hard caps on what can be permitted and used for groundwater management. The PFD properly agrees that treating the DFC and the MAG as management guides is consistent with the district's duty to manage the total groundwater production on a long-term basis. They also found that the district lacks authority to impose a mitigation fund as a condition of granting LCRA's permits. They also correctly found that the district has discretion and authority to require binding contracts or commitments, but the GM does disagree with the ALJ's elimination of that requirement, and we'll talk about that later. The ALJs properly upheld the general manager's formula applicable to LCRA progressing through the phases, and that was findings of fact 55. LCRA has already agreed to a majority of the formula except for one step, which DFC will apply to LCRA's production in the future. LCRA sought to essentially grandfather the DFC that's in place now. The ALJs properly disagreed. Finding of fact 56 states, examining LCRA's pumping in relation to the DFC in existence at the time LCRA seeks to increase helps ensure that LCRA is not exempt from changes in the aquifer conditions. LCRA essentially should not get special treatment. So we're going to talk about what's problematic with the PFD. So we found 4 major areas where we're going to recommend changes to the PFD. One, the PFD recommends removing the requirement to have binding contracts as part of a demonstration to increase production. The PFD changes the draft permit in a way that would allow LCRA to phase in its monitoring wells instead of having those wells ready to go prior to any production. Third, failure to include a prohibition on waste that's outside the definition of waste in Chapter 36. We'll talk about that. And then there are some technical errors that can be corrected by the board, and we think that's important to have a clear record and a consistent PFD. So let's talk first about binding contracts. The board should reject the removal of draft permit conditions such as requiring binding contracts or binding commitments to determine the need for beneficial use. Conclusion of Law 13C and Conclusion of Law 13D apply to special conditions 3C and 3D in the draft permit. Those special conditions require binding contracts. The PFD proposes to remove this requirement to submit binding contracts before LCRA may increase its pumping in the permit phases. Finding of Fact 54 states there's no compelling reason to require binding contracts, and as such, the ALJs just propose to get rid of it. Although the PFD's analysis rightly concludes that the district has discretion and authority to require binding contracts, the ALJs deem them unnecessary. So on the left of your screen, you'll see the GM's permit language showing a requirement for binding contracts to move from phase 2 to phase 3. This is the same language that also applies from phase 3 to phase 4, which the ALJs are also recommending be struck. On the right, you're going to see that this language is substituted by language replacing binding contracts or commitments with the requirement to add new monitoring wells in order to increase pumping. These requirements are not interchangeable. The ALJ's finding on this point rely on LCRA's likelihood of using the water beneficially, and they fail to consider the district's continuing obligation under applicable state law to ensure beneficial use and need, which is what binding contracts are for. The GM testified that binding contracts demonstrate that water is being put to beneficial use. Also, LCRA's own witness agrees that it is logical for the district to require binding contracts to show continuing need. The evidence also shows that it's proper to require these binding contracts, as General Manager Jim Totten testified that other phase permit holders are required to have binding contracts. Essentially, LCRA should not be treated differently here. To make sound decisions on progressing through the phases, the district needs reliable data, and to not base its decision on LCRA's likelihood of using the water or any other best guesses from from water conservation plans or drought contingency plans. So there are two concerns I just want to further highlight about binding contracts. Eliminating binding contracts creates an enforcement problem for the district, and the district should not be forced to extrapolate information from state water plans or water conservation plans. Second, you'll see on this next slide here, taking out binding contracts in one part of the draft permit and leaving them in another is inconsistent. So the ALJs conclude that the district does have a discretion and authority to have these requirements. So as such, the ALJs left in this requirement in Special Condition 8. And so Special Condition 8 is what's commonly called, the Cinderella provision. It's a requirement to show binding commitments on the 5th anniversary of your permit issuance. Otherwise, the permit expires. So the ALJs found the value and importance of binding contracts here And it's inconsistent to say that they're not necessary to show progressions through the phases, but then they are necessary at the 5-year point for renewal. So the GM accepts to the inclusion of conclusions of law 13B and D, and urges that you issue a draft permit that recognizes the obligation for need and beneficial use. So again, on 13C and 13D, the board should reject changes to the permit that would allow LCRA to phase in new wells without providing the data needed on the front end. The GM recommends rejecting these conclusions of law, which replace submission of binding contracts with adding in new wells. As stated in the GM's reply brief, this replacement could allow LCRA to phase in monitoring wells without providing the data on the front end to make decisions on progressing through the phases. And as evidence in the record shows, according to the district's management plan, that's GM Exhibit 10, monitoring wells measure water levels to detect declines to allow the district to consider appropriate action to avoid or minimize depletion of the water supply and to maintain and achieve water levels consistent with the DFCs. Without all agreed upon wells constructed and installed before there's any production, there's no baseline data to know how the aquifer reacted to pumping from the start. Therefore, the district could be kind of at issue with its DFCs. We're going to skip that slide. So the third issue, the board should not adopt findings on the definition of waste that are overbroad or not consistent with the definition of waste in 36. Conclusions of law 11 and 12 should be rejected or modified. The PFD proposes to eliminate the GM's draft transport permit special condition 1, which prohibits the transport of groundwater via the bed and banks of a river. PFD's analysis and findings on this point are overbroad and fail to state the applicable controlling law in full. The PFD states that the blanket prohibition contained in Special Condition 1 is overbroad and not consistent with law, presumably because the ALJs concluded that some permitted discharges in the river are not waste. See, as you can see in this slide, the ALJs leave in a broad standard condition on waste, but their PFD leaves the permit silent on transporting water in the river. A possibility raised by LCRA in response to a director's question about transporting water without a pipeline at the September 28, 2018 public hearing. And also, again, this possibility was raised by LCRA in their closing arguments. LCRA, in those closing arguments, estimates the losses from transport via the bed and banks of the Colorado River to be about 10% from Lake Travis to the Texas coast, which is, so essentially the GM was reasonable to put in this prohibition and to put transporters or any permit holder on notice of the risk of waste. And the GM did propose an amendment to the original Special Condition 1 to make sure that it is consistent with Chapter 36. This amendment would read as follows. Water withdrawn and transported under the permit must be put to beneficial use at all times and may not be transported by the use of the bed and banks of the river unless the permittee has lawful authorization for such use issued by the TCEQ pursuant to Chapter 6 of the Texas Water Code. Nor may the water withdrawn and transported under the permit be discharged to any surface water as defined by Section 11.021 of the Texas Water Code. So limiting the use of the bed and banks of the river for transporting water withdrawn under the district permit to LCRA when it's authorized by TCEQ to do so is necessary to comply with Chapter 36, specifically Chapter 36, Section 36.001. And additionally, this also recognizes the district's rules that include that escape of groundwater into a water course is waste. One might say, why include this provision if it is prohibited under the statute? The GM and the district have recognized other statutory provisions in its permits as a regular course of practice. So this is not sort of an anomaly to put the express
Natasha,
language.
You've exceeded
I
your
have.
15 minutes.
Oh, could I have just a moment to wrap
Okay.
up? Okay. Okay. So on technical errors, I will be as brief as I can be. The ALJs issued an exceptions letter to the PFD, and the board can change the PFD to correct technical errors pursuant to state law. Essentially, as you'll see on this slide, the PFD required the district to include surface water monitoring in the phasing formula. After exceptions by some of the parties, the ALJs turned around and said, no, we don't need to include them. However, the ALJs didn't make a global check of the PFD, and they failed to remove this recommendation 5 in the PFD, which would require surface water monitoring in the formula. So we're recommending that that come out. A very similar issue happened with standing, so I won't read over that, but you will be provided with this slide. And in sum, the PFD finds that the revised draft permits meet the obligations of the district. There are negative impacts of the ALJ's draft permit on binding commitments, monitoring wells, and waste. And we recommend the GM's draft permit. And then also there are technical errors within your authority to correct. Thank you for your time, and I can answer any questions.
Does any of the board have any questions for Natasha regarding her comments? If not, let me flip back here. I believe LCRA has 26 minutes left of time to rebut because you did not.
Would it be okay if we took a 5-minute break so that we could gather our thoughts?
If it's acceptable to the board, it's acceptable to me. Okay, let's take a look. It is.
And maybe people want to stretch their legs and
Sure.
go to the ladies' room.
I don't want it to become a extended, it's 8:10. Let's try to be in here by about between 8:17 and 8:20, okay?
Perfect.
if we could all get back to our designated location, if we could.
Let's all get started again. There we go.
All right, yes, please. We could get back to where,
And before we go back on the record, I want to assure everybody that I've been told there were no conversations about this permit in the restrooms. There is case law on that, just in case you're wondering. Don't ever do that.
that's right. Okay, prior to the break, everyone has given a presentation, and LCRA remains kept some time to provide a rebuttal, and so I'm going to turn it over to LCRA at this point and let you go ahead and make the remarks you wish to make.
Thank you. You have heard from almost every one of the protestants claiming that the ALJs are inexperienced. This is frankly just a red herring. The protestants are just frustrated that the ALJs didn't like the evidence that they presented. These are experienced ALJs who are capable of evaluating and weighing evidence. This is merely an attempt to get you to reweigh the evidence that, that was set before the ALJs. Several of the protestants have called for a remand of the permit to address local impacts. They rely again on the ALJ's supposed inexperience and call for this. Recharge and others recount of evidence is misleading, basically on purpose. The evidence regarding local impacts is in the record. The ALJs found that LCRA and the GM had addressed local impacts. Both LCRA and the GM's analysis considered local impacts with respect to Aqua and Elgin. LCRA's analysis using the new GAM with additional analytical information shows their investments in their wells and their ability to serve their customers will not be affected. In fact, Dr. Young, who is LCRA's expert testimony, is the lead developer of the model, and his testimony said that you could use the GAM in this case to analyze local impacts. And he did an analytical changes in looking at the wells where they were available. The ALJs not only looked at the GAM, but the ALJs also noted that the conditions in the permit lessen well interference. The LCRA's wells meet the spacing requirements. There's a 36-hour pump test that's required for each well. There's phasing requirements and monitoring that LCRA is going to assist with. And the GM has the ability to cut back LCRA if there are unanticipated impacts. So the permit addresses the issues or concerns with local impacts. With respect to the well field configuration that Mr. Terrell presented, Recharge would have you believe that there's something nefarious, which the ALJs absolutely rejected. The ALJs were not persuaded by Recharge's Exhibit 13, and you should resist the urge to reweigh the evidence that the ALJs have already considered. The modeling shows that Recharge's wells, which are yet to be drilled, will have just as great of impact on LCRA's wells as LCRA will have on Recharge. And there was plenty of evidence in the record regarding why LCRA chose the well field configuration that it did, and some of it relates to requests by the landowner and the need to protect the Houston toad. With respect to claims that the new GAM is wrong and the transmissivity numbers at the Griffith-Lee Ranch are wrong, this is also incorrect. Dr. Young's testimony in that gave testimony concerning the transmissivity at the Griffith-Lee Ranch. He said it's actually higher than what is actually in the GAM, meaning there would be that it would actually produce less drawdown than the GAM actually predicts. All of the no evidence complaints are simply wrong and misleading. The ALJs just rejected their evidence and found LCRA's and the GM's evidence more credible. Several of the parties have suggested limiting the permits to just 8,000 acre feet. But LCRA presented evidence that the entire 25,000 acre feet could be pumped without causing adverse impacts. And the ALJs who reviewed and evaluated the evidence and who do this every day, found LCRA's testimony and the GM's testimony on this issue more credible and rejected the evidence of the protestants. Anything else you want me to? And with that, we will close.
Okay. Does the board have any questions regarding the rebuttal comments made by LCRA? Go ahead, Mr. Sin.
Michael Semaine. Council, I think I heard, and I want to know if you would agree with me, that there, in the record, or that the record shows that the two judges that heard this case had not heard a water case before. Do you agree with that?
I'm sorry, I'm not sure I understood your question. It was a little hard to understand.
I'm sorry. The judges that heard this case, the ALR judges, was this their first water case? I think I heard that in the record, but I'm not sure.
I don't know. That wasn't anything that's in evidence.
Okay.
But I do know that the ALJs are experienced. In fact, the lead, one of the ALJs, she is the lead administrative law ALJ for the SOA.
Well, that's fine, but generally, or at least in my practice, lawyers specialize in certain areas. And so just because you're an experienced ALR, whatever it is, judge, SOA judge, doesn't necessarily mean that you are well versed in all cases that come before you, does it?
Well, I'll say this. They are experienced ALJs because they do this kind of work all the time. Just like lots of lawyers, they do lots of different kinds of cases and have the ability to weigh and evaluate evidence. You don't need to be a water lawyer to understand water law, especially when you have multiple parties providing all kinds of briefing that help you understand it. Now, I think these ALJs are experienced. They do know water law, and they have been working in this area for long enough to be able to evaluate the evidence. So I wouldn't be swayed by this notion that the ALJs somehow are inexperienced and therefore their evaluation of the evidence is incorrect.
Okay.
In fact, that will probably get you in trouble if you try to reweigh the evidence in this matter.
Well, but my question was, I thought I had heard this evening that it was in the record that this was their first water case.
It is not in the record that this is their first water case. I don't know where that ever was said.
Okay, well, I could have misheard it, but I thought that's what I heard. Thank you.
Is there any other questions of the board? If not, our special counsel, Mr. Ellis, has advised me he has some questions that he would like to ask.
Yeah, if y'all don't mind, would like to get a few things before the board goes into executive session. First off, I thought I heard from all of the protestants that they would not necessarily protest an 8,000 acre foot permit. Is that accurate? I know, Paul, you said you think that the permit should be denied based on the lack of evidence on local impact. But is it accurate to say that there's not an objection to an 8,000 acre foot permit?
What we said in our briefing. So what I said tonight was the board would be perfectly within its legal rights to deny the permit outright. What we also said in our briefing is that given the fact that there was no analysis of local impacts, like literally Dr. Young said, there was no analysis between the recharge wells and the LCRA wells, that you could grant a permit of 8,000 acre feet if there were mitigation in there. And so we did talk about the fact that there's mitigation, same as Bastrop had, what recharge has. So that's designed to address localized impacts, but because they have no evidence on the localized impacts, that's how we put it in our briefing.
Okay,
Mis-
what about the other
Yeah.
parties?
Aqua's position is consistent with what Mr. Terrell has said, in as much as Aqua's closing arguments and its position say LCRA has not met its burden and outright denial is appropriate. That said, Aqua would not object to 8,000 based on evidence that came in through the protestants.
Okay, Cole?
Yeah, I'll just echo what's already been said, is the city of Elgin would not object to 8,000 in certain permit conditions. That said, again, LCRA has the burden to prove up its permit and it hasn't done that, so.
Okay, Don?
We echo the sentiments that they have not met their burden, and that the permit should be denied. That being said, the only evidence that was put on by any hydrological, geological expert was to the extent that only 8 to 10,000 feet was a reasonable amount that could be produced from this area. And we would stand by that.
Marissa?
Thank you. Our position is similar to what you've heard from the other parties, but we would also insist that if a permit were granted, even if it were for 8,000 acre feet, that it would include a monitoring well system to evaluate the potential impacts on surface water.
Okay, so the monitoring well system, you actually mean a surface water monitoring
A
system?
surface water, thank you, yes.
Okay. Lynn and Emily, I know you're not satisfied with 8,000 acre feet. Clarify for me, please, that actually represents the phase 1 level of pumping, is that right?
Correct.
Okay, and is it phase 1 or phase 2?
It's, well, technically phase 2. Phase 1 is doing the monitoring well agreement and,
And the pump tests?
well, no, it's phase 1 is the monitoring well agreement.
Okay. And Natasha, the GM on the monitoring well agreements, is the GM okay with the ALJ's recommendation that the monitoring well agreements be due prior to drilling any wells rather than within 180 days?
The GM is okay with having flexibility for having the monitoring wells put in prior to production, but we want them all put in prior to production. So instead of 3 wells going in before number 1 and another 3 going in before phase 2,
Okay.
we want them all at the same time.
But you have the ability to work out that agreement with them prior to the wells being drilled, right?
Yes,
I mean, I don't,
it should be.
I don't remember seeing anything in the PFD saying that there's going to be a phased-in schedule of the monitoring wells. I think it said that you're going to work out the monitoring well agreement between the permittee and the GM.
Well, in essence, how they amended special conditions 3, C, and D, it essentially correlates to it phasing in the monitoring wells.
Oh, okay. All right. I'll take another look at that.
Okay, Greg,
Yes.
on the monitoring well agreement, again, this is Don Grissom on behalf of the Brown landowners. With regard to the monitoring well agreement, we had advocated that the monitor wells go into all 3 of the aquifers affected, because all the evidence was that there's drawdown in the Calvert Bluff and the Hooper, and so that the monitor well should monitor those aquifers in addition to the Simsboro. Thank you.
Okay. But that could be included in the monitoring well agreement the GM negotiates with the permittee.
That is correct. That's where we
Okay.
would recommend that be placed.
Although the permit doesn't specifically use the word mitigation, Emily, doesn't the recommended permit include the ability of the GM to limit future pumping based on the pump tests?
That is correct. And based on what happens through the phasing, as the application is, or as the permits go through phasing and monitoring is done, you do through the pump test and through the phasing have the ability to adjust the amounts that LCRA is able to take.
So one method of mitigating any potential harms is reducing what you can pump.
Correct.
But now, I'm going to go back to Paul. Paul, do you agree that we do not have the ability to require them to do monetary mitigation?
I do not agree.
Oh.
When somebody has not provided evidence of localized impacts and where there are known, you can't do 8 high-capacity wells spaced together like that without having localized impacts. And when the GAM doesn't cover that, that means that because you have put on no evidence of localized impacts, you can couple it with a condition saying we will give you 8,000 acre feet if you put together a fund that mitigates against the localized impacts that you didn't address with your proof in your application.
And do you think that this board has authority to require that?
To condition the permit, yes.
Okay. I may ask for a brief on that. Okay.
All right. The board is posted for an executive session. So at this time at 8:40 p.m., the Lost Pines Groundwater Conservation District Board is going to adjourn into executive session to consult with its attorney regarding posted matters in which the board may seek the advice of its attorneys under Government Code 551.071 or for any action on the agenda for which a closed session is permitted by law, and will reconvene in open session for any appropriate action on any matter considered in executive session. So we're going in at 8:40.
Okay.
I gotta make sure she doesn't go this.
Their focus it was fictional. Whether you either. And so their whole and then they say the modeling is not. She's best friend. Yeah, I'm sorry. I meant to ask this before and I just forgot about asking this question. Emily, I want to sincerely ask you if you believe this record contains adequate material, adequate evidence to support the eventual appeal of this board's decision should it grant the permit on the issue of impact on local wells.
I do.
Okay. Because my primary goal here is to make sure the board, when it issues a permit or doesn't issue a permit, that whatever decision they make on appeal is upheld. So to me, that's a critical issue. Thank you.
Okay, thank you, Mr. Ellis. We have consulted with our attorney. Before I entertain a motion, I want to thank everyone for your professionalism tonight. Everyone conducted this in a very productive manner. I appreciate your time and effort. The board recognizes we've got a major decision before us. And it reminds me of what President Kennedy once said. If I make the right decision, I got 100 fathers. And if I make the wrong decision, I'm an orphan. So that's the way, but we'll get through that. And with that, again, I want to thank you all for being here tonight. And I'll turn it over to the board for a motion.
Hit the button on there, please.
This is Cheryl Smith. I respectfully request that we feel that the board feels that we need much more information, and we would like to continue this hearing to a future date. That's my motion.
My name is Mr. Sherrill, and I want to second that motion.
Okay, a motion has been made by Board Member Smith and seconded by Board Member Sherrill that we continue this hearing because of the materials that were submitted here tonight. We feel like there's some additional information that would be helpful to the board in making our decision. So with that in mind, I'll take a vote. I want to do a roll call vote so that everyone can get that on the record. Board Member Smith? Yes. Board Member Sherrill?
Yes.
Board Member Semaine?
Yes.
Board Member Steinbach?
Yes.
Board Member Cook?
Yes, sir.
And Board Member Shoddy?
Yes.
The motion carries. And
Let me act real quick. We're getting a transcript of this done, and that should be available to us sometime next week. 4 to 5 business days. Okay. So
I don't mind paying additional costs to get it expedited if we need to. Okay.
That's the expedited. That's it.
I've been in litigation where it's been important to get an expedited transcript. So.
And all of you that have volunteered to provide your written materials to the board, if we could get that about the same time, the board would like to review the transcript and those written materials.
Yes, please get those to us.
In preparation for the continued hearing.
Yes.
Yes, whatever you used for your presentation tonight.
What was presented in here tonight as information that you have provided to us.
Yeah, at this time, we're not asking for any additional briefing or argument. We just want to see the materials that you presented tonight. Okay.
I'll entertain a motion to adjourn. Motion was made by Board Member Semaine and seconded by Board Member Steinbach. The motion has been made and seconded. All in favor? Unanimous. This meeting is adjourned. And again, thank you for everyone in attendance.